Hi, everyone. Harry here. It is Wednesday, and there was no court in Trump versus New York today. There will be tomorrow, but also early tomorrow, the big immunity argument in the Supreme Court. And I wanted to give you a preview of that. Tomorrow, I actually hope to be in court for Trump versus New York, and we'll give a full account of what I see. All right. The immunity argument. Very briefly to set the table, most of you know that Trump filed a motion for immunity in the January 6th case, and he made some very far-reaching arguments that he lost in the district court and lost in the Court of Appeals before a three-judge bipartisan panel. And there was the famous question there, are you saying if the president orders the Navy SEALs to assassinate an opponent, so use of federal apparatus to do something plainly outside beyond the pale of any presidential power, that would be would result in immunity. And Trump's lawyer, who's in a fix because Trump's conduct itself is so far outside the pale of normally accepted executive power, said, yes, that is what we're saying, unless, and this is the one of three main submissions on their part, unless the president had been A, impeached in the House, and B, convicted in the Senate. So that is the actual line they're trying to take. And I'm not even sure it's worth going through the tortured logic of it. They are also claiming, as the Trump team, that there's some kind of principle that the judiciary can't meddle in any way in what a president does based on a tortured, again, almost too nice a term, based on a nonsensical reading of a whole line of cases dating back to Marbury versus Madison, the fountainhead of judicial review in 1802 or 03, and they want to take a small exception there for truly discretionary conduct, which is beyond the purview of judgment from from federal judges, like giving somebody a pardon or just purely a choice of whom to nominate. And stretch that into an all-encompassing principle. And then there's all kinds of policy arguments that they're saying if a president were subject to criminal process, he or she would be cowed and be, not do the job they're supposed to do. And of course, in response, one can note that there's never been an issue before, and in fact, it is pretty clear that some presidents, most notably President Nixon, who secured a pardon from Ford, did have in mind the possibility of criminal prosecution. All right, the big issue here as a practical matter, because everyone is focused on timing, is whether the court will issue an opinion that goes only to Trump's circumstances or whether it is somewhat broader. And let me explain a little bit more. There's no way that Trump's conduct will ultimately be adjudged to be immune by the federal courts. Even the principle in civil cases, which is what Trump is trying to shoehorn the criminal standard into, says that there's immunity only insofar as the conduct is within the outer perimeter of official duties. And trying to foment an insurrection and prevent the peaceful transfer of power is the very definition, you could say, but certainly outside the line of what could be considered within the official framework. And that, again, is the civil. You'll hear about this tomorrow if you listen in. And if you want to listen in, I think go to scotus.blog. You'll also find commentary. It's a good place to listen. No relation or association with Talking Feds. But you will hear the case Nixon versus Fitzgerald bandied about, and that is a case that concerns the breadth of civil immunity. So there's many reasons in many cases, including another Nixon case, Nixon versus U.S., when Richard Nixon was brought to heel by the criminal process, and the court has made clear that a criminal case brought by the executive branch is far more weighty, far more things on the other side than a civil case brought by a private person. So the notion that they would endorse the same kind of immunity line for criminal and civil cases, I think, is a long shot in and of itself. But even there, we have many court decisions already holding on the facts that for analogous reasons and legal issues that Trump has not acted as alleged within the outer bounds of his official powers. So I don't see the Supreme Court or any federal court ever greenlighting Trump's claim of immunity. That's the good news. The bad news is it's all about timing. And, in the long run, maybe we're not all dead, but maybe the American experiment is, because the reason this has been able to freeze the proceedings in the district court is because immunity, which is what he's claiming here, is a special kind of claim. It's a claim not to be tried in the first place if you're immune. And as a result, the law provides an immediate appeal, because if you're vindicating that right and you wind up going to trial, you can't do it after you've already had that right abridged. And that's why he's managed to go up to the Court of Appeals. And then there was the whole brouhaha in the Supreme Court that was asked to take it even before the Court of Appeals ruled, didn't. Court of Appeals ruled, and then the Supreme Court took some 13 days before accepting the case and writing its own question presented. So I'm not sure when we will know. One day, when papers are made public, we will know what happened during those 13 days. But it seems to have been some kind of negotiation within the court for a specific question presented. And the one they wound up with is whether, and if so, when there's criminal immunity for alleged acts. And that matters a ton, because what it suggests is some members of the court are inclined, even in a case that doesn't present any tenable claim for presidential immunity, to state some principle that encompasses more than the case and greenlights immunity in other circumstances, whether and if so, when. You can just imagine, a president bombs an adversary somehow, somewhere there he's held for, or she's held for criminal process, and the Supreme Court would want to say, no, you can't be, you're immune for that kind of conduct. The reason it matters so much is if the Supreme Court states some such principle, the normal course would be to then remand that whatever their articulated standard is, let's say ultra epicenter core executive power, back down to apply the new standard. And in that instance, even if the courts below, and they would make quick work of saying this doesn't help Trump at all, that's another little delay up and down the federal courts, and that even in quick time is maybe a couple months, and we're looking virtually no possibility then of having this all-important case tried before the election. So the practical issue, there's a legal issue that matters but isn't presented here, because Trump will not be immune. But there's a huge practical issue. And if I'm listening to the opinion, and I will be tomorrow, what you want to hear is whether there are some members of the court, I'm suspecting Gorsuch and Alito and Thomas, who are trying to push the point that there should be immunity in certain instances. And that would suggest either a court opinion endorsing that view, or just a longer process where they dissent. But if the eventual Supreme Court case states some standard other than simply saying, as the special counsel is urging, as all the amici on the side are urging, D.C. Circuit is right, Trump loses. If it goes more broadly than that, then we're looking very possibly at a remand with very bad practical results on trying the case this term. The special counsel, aware of this prospect, has tried something interesting and unusual. Special counsel has argued to the court, whatever you decide here, remand for trial. Very different from what the U.S. Supreme Court normally does. It remands for proceedings consistent with the opinion. But they're saying remand for trial, and to the extent there are any lingering questions based on the standard the court adopts, they can be handled by the district court with evidentiary rulings or jury instructions. It's a way that the special counsel is saying, even if, as your question presented that you framed, court, suggests, you state something that is broader than what's strictly required to deny Trump's claim for immunity, you should not delay the trial at all. Rather, you should remand for trial immediately. They have a very sophisticated, excellent, and well-known to the court Supreme Court counsel, so that they'll take that prospect seriously. And of course, if there are 5 members of the court to do it, that can happen. But the court so far has shown itself to be basically impervious to these issues of hurry up in order to try to get the trial commenced at least, or finished ideally before the November election. So that the legal issue is big, but not as it applies to Trump. Trump should not get immunity, but the practical issue, and that will be a question of how the court approaches the case and whether it sees instances it wants to speak to other than Trump himself. That's a very big issue because it is tied up with the prospect of yet another kind of mini delay for a remand back up and down, which would almost certainly make trial not occur in 2024. That's the thing to be listening for. The justices will probably be talking over one another or toward one another. And remember, they spent these 13 days before deciding negotiating out the question. So they're well aware of these sort of stress points and pivot points as they concern not Trump's immunity, but the prospect, the very important practical prospect, but maybe one that justices think, well, that's not our lookout, of having Trump tried in 2024. So listen for that. Listen for a broader articulation than just Trump, and that will give you a real window onto what's happening with the trial when it happens, and if and when it happens. Because one more quick point, it's a federal case. If it hasn't happened by November and Trump wins, he can simply order the DOJ to drop the case. So the stakes here in terms of accountability and Trump's conduct are high. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.